In 1997, Indian women celebrated a landmark moment. This was when the Supreme Court formulated what are known as the Vishakha guidelines for institutions across the country to lay down procedures and measures for prevention and redressal of sexual harassment at workplace. And these guidelines itself were born out of the Bhavri Devi case. We know that Bhavri Devi, who was a Dalit woman, was working with Rajasthan State Women's Development Program, and it was her job to educate women and educate people about social evils like dowry, female infanticide, female feticide, and even child marriages. And it was during the course of this work when she prevented a child marriage from happening, and as per reports, this was a child marriage of a 9-month-old girl. She was gang raped by 5 upper caste men. And this was when the country woke up to the truth about there being no law to prevent such harassment, because essentially she was sexually assaulted and gang raped at the place of her work. This is when several women's organizations, and this is when you'll know why it's called Vishakha case, Vishakha guidelines, because several women's organizations, and these group were Vishakha and Women's Rehabilitation Group from Rajasthan, and Jagori and Kali for Women from Delhi. They are the ones who approached the Supreme Court demanding such guidelines. Now, the Supreme Court then in 1997 put in place these guidelines, and these were to be the law of the land till the Parliament actually enacts a law. So this was momentous in its own self. And then it took the Parliament 15 years to finally make a law, which is the law at present. We call it Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013, and this is the law that we'll be talking about in today's episode of Laws of the Land. I have with me our legal expert Bhadra Sinha, you have me Apoorva Mandhani, and I have with me Professor Surabhi Singh, who is an assistant professor with Jindal Global Law School. She is a women's rights lawyer and researcher, and she holds a master's in women and gender studies and sexual diversity studies. So like you've seen in our previous episode, she is the best person to talk about this law with us and to let you know more about what this law is all about. Welcome to our show, Surabhi, and thank you so much for joining us.
Thank you so much for having me.
Bhadra, would you like to take this forward now?
Sure. Surabhi, as Apoorva has already given a background with regard to the entire case, but for the sake of your viewers, I would like you to just briefly tell them what exactly was this case about, and what were the arguments that that were addressed in the Supreme Court when this case was being discussed?
Okay, so like Apoorva mentioned, the Vishakha case started with a public interest litigation petition that was filed by a collective of women's organizations and NGO. Vishakha was one of them, before the Supreme Court of India. And the first and foremost issue that these organizations brought before the Supreme Court was that there is no law in the country that is protecting women from sexual harassment at workplace. While sexual harassment at workplace remains a grim reality for many women across the country, and it's worse for women who are working in, say, the unorganized sectors, who are working in the fields, who are agricultural laborers. And in this background, these petitions came to be filed before the Supreme Court of India. And the first and foremost argument that was made was that we need something immediately. We know that the Parliament has not enacted a law on this issue, but at the same time there are these incidents such as the Bhavri Devi case happening. And to give you a little bit of more of a context here, these organizations were very unhappy, rightly so, with the way the Bhavri Devi case was handled by the criminal justice system.
Right.
So her FIR was delayed, and consequently the medical examination that she was supposed to undergo was delayed. And therefore, when these delays happen, any direct evidence of rape is difficult to acquire, right. And therefore, in consequence of the trial, the case becomes difficult to prove. And these factors unfortunately worked against the case. And ultimately, when the trial court in this matter gave an acquittal of the accused, this lack of evidence didn't help. At the same time, the characterization of this case by the trial court was framed in the manner that, upper caste men can't rape a lower caste woman. Two of the accused were related to each other in an older person and a younger person capacity, and the court characterized this in a manner that an uncle won't rape a woman in front of his nephew and vice versa. The head of a village won't rape a woman. And so this uproar against this acquittal also came from the fact that the criminal justice system didn't give any redressal to Bhavri Devi. And these organizations therefore said that, okay, then in such a case, what is the responsibility of the state? Because the state is ultimately the employer of Bhavri Devi.
Right.
And therefore, the articulation of the case became that we need something that is an alternate to the criminal justice system, because in cases such as these, clearly the criminal justice system is not working. And therefore, the first argument before the Vishakha case in the Supreme Court was that we need something immediately. We need a law that protects women from sexual harassment at workplace, which is not within the current criminal framework, because that is not in certain cases working. And therefore the Supreme Court accepted that argument and said that clearly there is an immediate social need for protecting women from sexual harassment at workplace. Until the parliament comes up with a legislation of its own, we are giving these guidelines, and these guidelines will be binding on all employers across India to protect women from sexual harassment at workplace. Now, the judgment came in 97, but the judgment was also a bit of a work in progress. So the guidelines were not something that the court ultimately decided on the last day of the judgment. A lot of work went into the formulation of the guidelines itself. The state and the state's lawyers that were present before the court, the lawyers of these women's organizations, all of them put their mind together, put ideas together, and the ultimate document that emerged was what are known as the Vishakha guidelines.
So it was not seen as an adversarial litigation.
It was not completely an adversarial litigation.
Because this is a very rare instance where a court stepped in because of due to vacuum of the law.
Yes, absolutely.
But there was no opposition from either the central government or the states. So it was a collaborative effort of all the parties.
It was a collaborative effort, but credit where credit is due. It was the women's organizations that took the first step and took the initiative, and they put in a lot of work during the course of the case to make sure that some guidelines came out of the judgment.
But then why so many years to bring in a law?
Urgency was clearly highlighted when the Supreme Court gave out the guidelines, but why did it take so many years for the Parliament to bring about a law then?
So we see from the documents that are available to us publicly, we see that the judgment came in 97.
Right.
And even then, the judgments that appear post that in specific cases continue to cite the importance of Vishakha and how there needs to be a law that has to be made by the Parliament. Unfortunately, at the Parliament's end, the first time we see a draft that is floated by the then Central Ministry is in 2007. So that is still a 10-year gap.
That's right.
The only explanation that is kind of obvious is some kind of political lethargy behind putting out a law that is protecting women from sexual harassment at workplace. Meanwhile, agreed, the Vishakha guidelines were there. They were working, and offices were using them, particularly state offices. They were amending their service rules to incorporate the Vishakha guidelines. All of this was happening. But the Parliament was definitely working slowly. In 2007, we see the first draft. Then, the first time anything is tabled before the Lok Sabha is in 2010. Between 2007 and 2010, there were only public comments that were being invited over the draft. We were still tweaking the draft around. Then, once it appeared before the Lok Sabha, it went before a standing committee of the Lok Sabha. And the standing committee made its own suggestions. The Lok Sabha deliberated on them. It accepted some, rejected some. And after the Lok Sabha, the Rajya Sabha fairly quickly passed the bill. Around that time, unfortunately, what had also happened that in end of 2012, we see the Delhi bus gang rape case happen.
Yeah.
And around that time, there's a lot of pressure on the executive government to make sure that there are enough laws on the books that are protecting women from gender-based violence. And if you recall that this is around the time that there's a committee constituted by the government which proposes a lot of criminal law amendment
Verma
reforms.
Committee.
Yes. So there was a bit of a push in the direction of making laws for women and keeping them on the books as soon as possible. So at that time things gained a little bit of a momentum, and therefore the bill was finally passed at the end of 2012. It's notified in 2013, and the end of 2013 is when the POSH Act as we know it has come into being.
So when we see the guidelines by the Supreme Court and what eventually was notified, are there similar? I mean, similarities, or did the government bring about certain changes? There was some sort of divergence. If you could just throw some light on that.
So there are fundamentally very conceptual similarities, and credit goes to the Vishakha guidelines for bringing some of these new concepts into the place at the first instance. So for the first time we are talking of a very wide definition of sexual harassment at workplace. We're not articulating it in terms of modesty or outraging these very archaic Victorian concepts that we have inherited into our criminal system. We're not using those anymore. We're using this in terms of what is unwelcome, what is affecting one's bodily integrity. We're using concepts of consent, and for the first time we are thinking of not only physical harassment, but we're thinking of verbal as well as non-verbal conduct.
That's right.
And the second important thing that the Vishakha guideline put into place was that they said there has to be an alternate redressal mechanism for these complaints, and this redressal mechanism is the onus of the employer. So the employer is supposed to set up an internal committee. The composition was determined by the Supreme Court, and this committee has to hear these complaints in a timely, systematic manner. What the POSH Act then did was, it provided clarity to some of these procedural mechanisms. So what it did was that it retained these structural concepts from the Vishakha guidelines, and then it added to those by saying that, for example, if a complaint is to be initiated, should it be written? How many copies should be supplied? What is the timeline within which a complaint can be presented and beyond which it may be barred by limitation? What is the process of, say, exchange of documents? What is the process of use of witnesses? So these are some of the procedural clarifications that were added by the POSH Act in 2013, which made the redressal process smoother and clearer.
For our viewers, could you maybe elaborate a bit more on this procedure, just to let them know how they can initiate such a complaint, if at all, with their employers?
So now under law, under the POSH Act, any workplace, and this workplace has a very wide definition. It could be any office that you're running out of your home. It could be a home-run business. It could be a complicated multinational. It could be a small branch of a multinational. Any workplace with 10 or more employees has to have an internal committee.
And these have to be full-time employees, or can they be contractual
They
as well?
can be contractual, they can be interns, they can be volunteers.
Okay.
You don't even have to pay them for them to be protected by the umbrella.
Okay.
And once this committee is set up, any person or who has to be an aggrieved woman under the Act, because that is the scope of the Act, can initiate a complaint before the committee by providing a written complaint to the committee. If an aggrieved woman say for any reason is not in a capacity to write it or to articulate what their complaint is, then it is the onus of the complaints committee to help that woman out. That is provided for under the POSH Act, that you have to provide all reasonable assistance. Say that person needs a typist, say that person may be only in the capacity of dictating it to you, say there is a language barrier. Okay, so these mechanics and these facilitations have to be done by the internal committee now. And this complaint has to be in a written form, and has to be made within a period of 3 months of the last date of the incident of sexual harassment. So if there has only been one incident, you have to submit a complaint within 3 months from that incident. If there is a series of incidents, which is very likely, then from the last date of any of the incident in such series, within 3 months you have to file a written complaint before the internal committee. Now, how does one make sure the complaint reaches the committee is a very crucial factor, because it is the onus of the employer to make the POSH Act and the POSH mechanism as accessible as possible. So you have to ensure that there are several mechanisms by which a complaint can be made available to the complaints committee. It can be done anonymously through a Dropbox. You can send an email. You can then take a printout of said email, send it by registered post, you can courier it, you can hand it in person. So there are these mechanisms by which this complaint can be made available to the complaints committee. Once the committee receives the complaint, then they will begin to act on it.
Okay, but since you've now described it, and for a while you've mentioned how this is an alternate mechanism without the involvement of the state, how does that work in your experience? State not being involved in in an incident which sexual harassment generally is seen as, crime against the society, so to say. So how does that work?
In the sense, like, what would be the nature of proceedings under this law? Because generally, as you said, before this law came into place, we only had the Indian Penal Code, where the state was involved in investigating these kind of cases. So what exactly is the nature of these proceedings?
Okay, so at the outset, I would not call them criminal proceedings, because the Indian law is organized such that all criminal proceedings are the onus of the state. Okay? Private parties in their capacity cannot carry out criminal proceedings. So they are by their nature civil proceedings, but this becomes slightly complicated if your employer is a government entity. Okay? Because as the state, they have some additional obligations. As a state employer, they have some additional obligations which are covered under this body of law, which is called service law. So there are these, so then those proceedings when the state is the employer may be known as administrative proceedings or even service law based proceedings. But when your employer is a private corporation or a private person, they're simply civil proceedings. You mentioned what is the involvement of criminal law in all of this. So I think it's important to clarify that the criminal law provisions continue to operate.
Right.
Should the aggrieved woman decide to approach them or decide to trigger them.
So she has an option to even go,
Absolutely.
This doesn't bar her.
And avail both the remedies at the same time.
Remedies can parallelly take place, and one does not prejudice the other.
That's also important, because it may be, it's likely that person may get a clean sheet under this committee inquiry, but the IPC evidence is, the requirement is very different.
One should not prejudice the other,
Right.
and not availing one should also not prejudice the other. Like, you cannot, at the end of the day, ask in an internal complaints committee hearing that why didn't you choose the criminal law angle? If you were so aggrieved, you should have filed a criminal complaint, you should have filed a FIR. But these are, as per the law, these are not questions one ought to ask. One proceeding does not prejudice the other. It's the aggrieved woman's choice which one she wants to use. What is now happening is that, because I mentioned that these are civil proceedings, but in cases of private offices and private employers, because the process is completely controlled and in a sense supervised by the employer and the committee of the employer. There is a little bit of a lack of transparency in what is happening in a given POSH hearing, and because the law also requires maintenance of confidentiality.
Right.
You cannot publicize details, you cannot hand out personal details. So in such a case, what happens is that, in my experience as a person on some of these committees, what I've seen is that there is this effort of image management in a lot of cases, that the employer does not want their reputation to be sullied in the market, that they are running an office where sexual harassment incidents are happening, or they want to protect a certain valued employee from allegations of sexual harassment. So they will try to not trigger the POSH mechanism as far as possible. Say an employee has an informal conversation with their boss, saying that I'm facing some issues of harassment. What do you suggest I do? The first effort in such cases by these private companies often is to not let a complaint be sent to the committee. And they'll try various mechanisms. For example, they may offer money. They may offer a monetary settlement. They may say that we'll transfer you, we'll change your reporting department. And in some cases that is also fine, as long as the aggrieved woman gets what she wants and the harassment stops. But it is often used as a shield or as a curtain to push under the rug systemic issues of sexual harassment, or issues that provide a larger comment on what kind of a workplace is it. Is it a good workplace for women? Is it okay? Is it cognizant of gender-based issues? Is it sensitive enough? So there is this slight this alternative mechanism has made it difficult for one to monitor and get clear data on what is the rate of incident of sexual harassment in these private workforces. So once a POSH mechanism is triggered and a complaint is made, the POSH Act requires that the complaints committee has to maintain what is known as an annual report. And under the annual report, they have to have numbers of how many complaints were filed, how were they disposed. They can't, of course, include personal details or too many details. This report goes to the employer, and the employer in turn has to file an annual report with a district officer.
Right.
Now, if the POSH complaint is never triggered, it will not appear on either of these reports.
So the idea is not to let the complaint be registered, right?
Yes.
So are there any repercussions for, say, an employer discouraging such a complaint to be filed?
It's very difficult because it can only happen once, say, the aggrieved woman in the question says that she feels that all efforts were made to discourage her from filing a POSH complaint, and say she was fired from her place of work, and then she challenges that termination. And then, in such cases, which often become contractual dispute cases, we find that these arguments that I was not allowed to access the POSH mechanism come up. But even within this framework of contractual law, there is little repercussion for the employer, because it's very hard to prove that somebody really did not let you access the POSH mechanism or discourage you from accessing the POSH mechanism. Now, of course, none of this isn't written. These are oral, informal conversations happening in office settings. And so far as state-based organizations are concerned, because they have little more responsibility towards the employees, there have been cases where employees have filed what are known as writ petitions.
Yeah.
Okay, so in these writ petitions, these employees have argued that the law is not being implemented in the correct manner.
Right.
But can't a private an employee of a private organization move a writ petition?
It's a very difficult case. First of all, a writ only lies against a state entity or an entity that is behaving like a state. Okay. So as a result of which, most private offices are outside this definition, and a writ petition cannot be filed against them. And therefore this writ remedy is not available against most private offices.
So if there is a grievance by a woman employee, and if an employer is not paying heed to it, so what is the remedy left with that woman employee?
One of the remedies that is available to such an aggrieved woman is to approach the local committee, which is set up by the state, and file a complaint before the local committee. And in the complaint mentioned that they've tried to access the POSH mechanism, but it has not been possible for XYZ reasons, and therefore they would like to instead approach the local committee and have their grievance heard there, which is also one of the reasons why the local committee was established. The local committee deals with workplaces with less than 10 employees. It also deals with very informal workspaces where, say, one person is working as a domestic worker in a house, and they have they're not a team, of course, they're an individual person, and to help such persons, the local committee was set up at the district level and supposed to be managed and overseen by the state governments. And the third avenue is that if, for example, you're not able to access the POSH mechanism, then the local complaints committee is an avenue for you to go and file your complaint before.
What is the compliance level of these committees?
It's the same as the internal committee. The compliance mechanism is exactly the same. They are supposed to be submitting these annual reports. They are some supposed to be submitting these, like I mentioned, these annual reports to the government. And because these are state-based, state-run committees, the composition of these committees is also such that they will not have people from a certain workplace. They will have people who are who can be so for example, the composition is such that the chairperson of this local complaints committee is supposed to be a person who has an expertise in these kind of issues, and they're supposed to be an independent person. Then there are supposed to be 2 employees who can be any employees from anywhere in the government. They're supposed to be women as well, and there is a 4th person. So there are 4 persons on the committee envisaged, and since they are not directly related to your employer, they are supposed to be less biased and therefore impartial as to the process before that.
But do we have these committees actually operating? Have all the state governments fulfilled this requirement under the law? Has there been any study with regard to this?
No.
Yeah.
So unfortunately, we struggle with a lot of lack of data on this issue. In 2019, in fact, a lot of state governments and the ministries at the state level that look after women and children issues, they started taking notice of what these local complaint committees are doing. So especially in Maharashtra, in Telangana, they issued notifications to these committees and asked them, what are you doing? What is the data that you can provide to us? In fact, they increased their ambit of work and even asked private internal complaints committee to submit data to the state governments, because that was also not happening on a very regular level and in a way that was very transparent. So there has been this effort to make this more transparent, gather more data, but we're still in a very premature stage. We don't know even if these local complaints committees are existing on paper. Are they meeting regularly? Are they being trained? What kind of hearings are they attending? How many hearings are taking place? we have little to no information to go by.
You've spoken about the procedure before till a complaint goes to a committee, but what can a woman expect, an aggrieved woman expect once the complaint reaches this internal complaints committee or local committee? Could you what sort of evidence does she have to give? How long does the procedure take? Is there a timeline? If you could tell our viewers a bit about that.
Absolutely. So once the complaint reaches the committee is supposed to immediately give a copy of the complaint.
Just to intervene here, when we talk about complaint being filed, so what sort of action by the other person can be taken as harassment by the complainant? In the sense, as you said, it can be verbal, it could be non-verbal. So if you could just explain that also a little bit, in the sense, the circumstances under which a woman employee can go ahead and file a complaint.
Okay, so there's broadly 3 kinds of conducts that the Act recognizes can be sexual harassment. They can be physical, of course, where there's touch. They can be verbal. So directly in a conversation in a workplace, you're remarking on somebody's body, you're remarking on somebody's looks, you're remarking on say their romantic history with another colleague.
Okay.
Then all of this can be construed as sexual harassment. Then there is the non-verbal conduct about it. Say 2 colleagues in a workspace are talking about an aggrieved woman's appearance.
Okay.
And she happens to overhear it.
Okay.
Or she comes to know of it through somebody else. I have worked on a case where there was a boss who, whenever a certain employee would come into the office, would start playing a certain song on his computer. It was one of those very kind of obscene numbers in order to make that woman uncomfortable, and she would get very uncomfortable. So this is also an example of a non-verbal type of sexual harassment. So making jokes about a third party, remarking about a third party, commenting on a third party in their absence, all of this is non-verbal sort of conduct which constitutes sexual harassment at workplace.
Okay. So then, as Apoorva asked you, that once a complaint is filed, then what kind of evidence should be led? If you could just.
Now I'm going to go into ideally what is a good practice instead of what the law requires, because I think that's information that everybody should know. Right. So a complaint that is put before the committee should ideally be as detailed as possible.
Okay.
And as far as possible, it should be chronological.
Okay.
So if there has been a series of incidents, then ideally one should, as far as possible, put them in a chronological manner, make sure no incident is missed out, and to the best of one's memory, one can put exact or approximate dates to it. If you think there was someone who witnessed this harassment directly, was in the vicinity, or was privy to a conversation which was construed as harassment, then those persons' names should be added. If there are no direct witnesses, as often there are not, and you as an aggrieved woman had told of this incident to, say, a family member or a friend or a colleague, then you can mention that as well, that I was so upset that I mentioned this to my friend, or I narrated this.
Right.
If it happened over a chat or messages, then all of this information should be mentioned in the complaint. So this, looking at it in an overall manner, gives you a list of dates as well as a list of witnesses that the complainant can then later use before the complaint committee. Once this complaint is given to the complaints committee, what they do is that they give a copy to the respondent, and the respondent is given an opportunity to respond to this. They usually do this by filing another set of documents of their own. The respondent can also produce witnesses if they like, and they can be either the same witness as the complainant or another set of witnesses. Once all of this is before the complaints committee, the process that is now followed is that ideally both parties should be given a chance to ask questions of the other party.
Okay.
Now this is not a very set requirement, because this alternative mechanism was envisaged as something that private parties can handle between themselves. The process is not very formal, neither is it very strict.
Okay.
So a lot of times it is the discretion of the complaints committee to see which way to take it. If it's a very complex case, they may want to allow examination of witnesses, they may want to allow cross-examination of witnesses, they may want to allow written arguments to be filed, they may want to allow, if either of the party wants to file additional documents, they may want to allow that as well. So, and if it's a case that does not require such long process, and if that's what the committee decides, then they may just decide on the basis of the complaint and the reply that is done before them. So the process can vary from being very simple to being quite complex.
I just wanted to know one thing. So, if an employee faces harassment outside the office, outside the workplace, can she resort to this mechanism? And another question, joint question, is that suppose the alleged harasser is not part of that particular office, but she's gone on an assignment on behalf of the office, or for some meeting, and is harassed by somebody else from some other organization. Does this mechanism kick in then as well?
So there are two answers to those questions.
Yeah.
One is that the POSH uses what is known as an extended notion of a workplace.
Okay.
So if, say, an aggrieved person is traveling outside of her workplace for work, it can even be like an office-based retreat, it can be field work, it can be going to meet someone, interview someone.
Right.
And if in the course of that they are harassed, then POSH still applies.
Okay.
And say the respondent in such a case is not from that office, but for example is from another branch office that they met at the retreat, or is working in the canteen of another place where this person is gone and they have been harassed, POSH can still be triggered. POSH still applies.
Another, I'm very inquisitive to ask this question is, do you think that this law should be made gender neutral now?
I think eventually, yes, because the law as it is right now, it works for women, but for example, it does not work for people who do not identify as a woman.
That's
or
right.
a man. Okay?
Yeah.
It's not queer friendly.
Yeah.
It's not as of now on a literal reading available to say trans people. Although after the Trans Rights Act has been passed, that act in itself has some mechanism of an employer treating a trans employee in a non-discriminatory manner, making sure that they're not undergoing any harassment, but that is still not completely connected to the POSH process. The POSH process is still very different and still right now only applicable to women. So I think eventually that is what most countries around the world have done, that they have gender neutral laws in their office spaces, but we have to look at this within the larger context of our society, where women disproportionately face much more violence than men. That is one. Secondly, women have only very recently started entering formal workspaces. Okay, and when we talk about formal workspaces, we don't only talk about offices where women, earning a decent sum, or they're upper caste, middle class women. We're talking about women who are, say, migrating from a rural setup to an urban setup. They are losing the social support that they have. They are new in a society. They're, for example, entering the service industry. And these women need that extra protection that the law currently offers them. Because they are vulnerable to a lot of harassment, a lot of discrimination. And I think till we change these scenarios drastically, these social facts, putting in a gender neutral law would not be the right thing to do. Yeah. But at the same time, one must want to think of alternative ways in which this still remains available to people who do not identify as a woman, or who do not who maybe identify as trans but still want to access the workplace sexual harassment laws.
So basically what you're suggesting is that first let the women actually be able to utilize the law in a proper manner, and then probably the next step would be to make it more
yeah, absolutely. Because whenever this question of gender neutrality as an aim, as an objective arises, of course that is a goal, right? But the path to that goal is difficult, and it'll take time. If we just overturn it today, it puts women in a much more precarious position.
Right.
So we don't want that.
Right.
So that's why.
Okay, so that's one thing that maybe we can look at as a goal for POSH. What do you think of the law as a whole? Does it have enough teeth to act as a grievance redressal mechanism for women, or are there certain areas in which there can be tweaks for the law to be made stronger?
I think what has happened in the past few years is that since 2013, most private workplaces have started employing POSH in a very mechanical manner. So if the law wants them to have a committee, they'll have a committee, they'll have the requisite number of people in it, they'll hold hearings, all of that. The problem with the processes is the quality of the process that these people are using. So a lot of times the problems that I find with the implementation of the act as it is that the law is used in a very mechanical manner. Okay, so it's now become one of those compliance based laws that we do and we just kind of move on, and so the objective that it must ultimately create a safe workspace, that it must protect women from sexual harassment at workplace, it must be gender sensitive, it must be survivor centric. All of these goals are somewhere lost in the process because the people who are implementing it are not taking care of it, and unfortunately if they are not taking care of it, there is very little repercussion on them as long as they're following all the the checkboxes.
Yeah.
It is fine from a compliance perspective, and therefore there is this mushrooming of a lot of these companies and small businesses that help you with POSH compliance.
That's
but
right.
if you really closely examine their business and ask them, what kind of survivor centric practices do you do? If you train people, then what kind of training do you give these people? Do you just tell them what the law is, or do you tell them how to handle such cases with sensitivity, with making sure that the wishes of the survivor are central to the whole process? They will not be able to answer these questions.
So that's what we can aim for the law to become. Absolutely. Not just a compliance burden, but actually a law which can help women, help an aggrieved woman to get redressal and get her grievances addressed,
and probably make the workplace a healthier,
right
having a very healthy environment.
All right, with this we've reached the end of this episode. Thank you so much for joining us, Surabhi. Thank you, Bhadra. I hope you enjoyed the episode. We've been getting a lot of requests on the sort of laws that you want to see covered, and we've added them to our list. So make sure that you send us requests as well, and do let us know what you think about this episode and even this show. Thank you so much for joining us.